Hello, I'm Christine Bentley.
And I'm Kate Wheeler. Welcome to The Practice, a legal news show brought to you by AdvocateDaily.com and SiriusXM What She Said. On The Practice, we bring you our take on the legal issues of the day, along with the sources from AdvocateDaily.com.
Now, new trademark legislation is expected to come into force by the end of the year, and with that comes major change. Here with us now is Toronto IP lawyer John Simpson, principal at Shift Law, who has all the details. Welcome to the show, John.
Thank you. It's good to be here.
Let's start with some background on this. Why is the federal government making changes to the legislation?
Well, the government says that they want to align Canadian trademark law with international standards and modernize Canadian trademark law and make it more streamlined and accessible to businesses.
Okay, so I understand there are some major changes as part of this legislation, but which is the most significant?
The most significant change is the removal of the requirement to use a trademark before you can get a registration. And that's significant because traditionally, for the past 140 years, Canadian trademark applicants to register a trademark, have had to demonstrate that they've used the trademark or declare that they've used it or propose to use it. That's no longer going to be the case.
Why does that matter?
Well, it matters a lot because what's likely to happen is that applicants from around the world are going to be able to file applications and secure trademark registrations in Canada without any intent to use that trademark in the course of a business. And so they might do that, for instance, just to sort of squat on an inherently appealing brand or something that they know that someone else might want with the hopes that they can cash in at some point, but without any immediate plan on using it.
Isn't that similar to what some people do on internet domains?
It is. It's a lot like that.
Why would somebody do that?
Well, as I mentioned, they could do it for various reasons. They might have some plan to use a trademark at some point down the future, contingent on a number of things happening that may not, or maybe for a more mischievous purpose, simply to try to shake down someone for money.
I understand there is a change to do with a hyphen.
One of the more minor changes in this new legislation is going to be to remove the hyphen from the word trademark, which is a welcome change in my view. It'll make it a lot easier to spell.
I think lawyers will like that.
They will.
Finally, is there anything that you advise Canadian businesses to do in anticipation of these changes?
Absolutely. I think it's more important than ever for Canadian companies to register the trademarks that they're using so that they're not going to be in a position where some foreign applicant registers a trademark and puts the company in a position where they have to change their trademark after many years of use.
Thank you, John Simpson, for being on The Practice today.
Thank you. It was great to be here.
And that is today's edition of The Practice, brought to you by the team at AdvocateDaily.com and us here at What She Said Radio on SiriusXM. I'm Kate Wheeler.
And I'm Christine Bentley. And remember, you can see more online at our respective sites, AdvocateDaily.com and WhatSheSaidRadio.com. And please listen daily at 10 a.m. Eastern to Canada Talks on SiriusXM. Bye for now.